Good afternoon, everyone. How's everyone doing? I'm Craig Wagner. I'm with Lance Harrison. We both are attorneys for the Utah Association of Realtors. We're excited to join with everyone today and talk about some of these legal hotline questions. Recognize that it was short notice that we kind of advertised this, so we're glad that you could join with us. In kind of the theme of Halloween and kind of the questions that we've received on the hotline, Lance and I do want to talk about a couple of things, but if you do have any questions, feel free to comment in the comment section of this video, and we can certainly address those and address as many as we can. I do want to address my legal post from last week. It looked like that generated some interest with many of you, and so we do want to touch on that. So first things first, just kind of in this idea of maybe hotline horror stories or things that we've heard about. Lance, I want to share a little bit with the stigmatized property statute and maybe ask you a couple of questions based on that. So I'm going to go ahead and share my screen. And I'm going to show the actual statute dealing with stigmatized property. So in the Utah statutory code, you have the definition of what a stigmatized property is. And there are a number of things that create a stigma potentially that the legislature has said, look, a seller does not have an affirmative duty to disclose. Lance, can you maybe walk us through kind of those items of stigmatized property?
Yeah, for sure. So I just want to say, first of all, that sometimes we think of a stigmatized property as a bad thing, right? In terms of disclosure, stigmatized, you can think of it as a good thing. If it's stigmatized, you don't have a duty to disclose, right? And so the legislature is saying, if these apply, it's not material, so you don't have to disclose. So sometimes there's some confusion about that, and they logically we think, oh, stigmatized, maybe we misunderstand that and think, oh, that's a bad thing. But in this case, it's actually kind of a good thing. You don't need to disclose. So what does that mean? It's very specific, right? We can look at the rule and it looks like there's 5 things, basically, kind of 5 general categories that are in that stigmatized property statute. So the first one, site or suspected site of a homicide, other felony, or suicide. So those are 3 of the big ones, right? And a lot of these things come up, is this, and if it's a felony, it's in it. If it's a homicide, it's in it. If it's a suicide. So 3 things really quickly. And then the other, B, doesn't come up that often, but it's important to remember that this is part of it. An HIV infected person or suspected of being infected by HIV, that's not going to be material. So that's part of it. And then the third one that comes up quite often, and maybe the most often, is going to be meth. If it has gone through the proper avenues of being cleaned and decontaminated and reported to the health department following the statute, then that also is going to fit into the stigmatized property, so that it's not a material fact anymore. And that one probably comes up the most for me on the hotline, along with other things like felonies after that, probably.
Yeah, so maybe we can kind of touch on that a little bit. So the dealing with meth contamination, because I too get quite a few calls dealing with meth contamination. If the property tests positive for meth, what are the processes that a seller needs to go through in order to avail themselves of the protections found under the stigmatized property statute?
Yeah, so if we look down here on C, right, and it cites to this Reporting and Decontamination Act. So what that is going to do is outline what you need to do to make it a stigmatized property. And that generally is, you get a test, it comes back positive, you report it to the health department, they're going to add it to their list of contaminated properties. Then you're going to get it remediated professionally. They're going to report that back to the health department. The health department removes it. They make sure it's been cleaned. They now remove it from the list of contaminated properties. And that's kind of the process that once that happens, the statute says now that you're safe, and now it enters into kind of that safe harbor of being a stigmatized property. So that's kind of the general process.
Yeah, and really the background to this statute. So that this information may be important to some buyers. Some buyers absolutely would want to know about previous contamination, or if the property was a place of a homicide or other felony or suicide. For some buyers, those things would be important, and there may be a stigma about those previous occurrences. But the legislature said, look, there isn't anything with regards to the use of the property itself that has been affected. The value hasn't been affected. And so that's why they've carved out these exceptions, deeming these things to be immaterial as far as a duty to disclose to potential buyers. It's a safe harbor for sellers. Now, Lance, let's say a buyer or a buyer's agent asks the listing agent point blank, was this property ever contaminated by meth contamination? And you know that the property has previously been contaminated, but gone through the proper channels of remediation. How should a listing agent respond to that inquiry?
Yeah, that's a great question. So first of all, a listing agent should pause for a second and be careful about how they respond, right? Because of course it all goes back to the seller and what the seller has given them instruction about disclosing, right? Just because the seller is in a stigmatized property statute, or maybe in that safe harbor, if the seller wants to disclose or is giving you permission to disclose certain things, great, you can disclose those. If they haven't, then I'd be very careful about how you answer that question. And of course, you can never lie. You can't be dishonest. So if you're being honest, you say, yeah, actually has, but you're saying that without the permission of your seller, I think that's a problem.
Yeah, no, absolutely. I agree with what you said. And I'd go a step further, that really you need to have that dialogue with the seller and impress upon them, look, if I'm asked this question, I can't lie. So either you don't give me authorization to disclose, which for most buyers, they're going to say, okay, why aren't you being as transparent? Or two, you be transparent and you can control the narrative, especially when it comes to meth contamination and the subsequent remediation. If you're transparent saying, yeah, we previously had this issue, but here are the steps we've taken to remediate the issue. It's now been taken off the contaminated property list. Again, in a seller's market, most buyers are going to be comfortable with that, and they'll frankly probably do their own due diligence on the issue as well. But they're asking for a specific reason, that it's important to that particular buyer. So you can't lie, because if you lie, then you get into misrepresentation claims, fraud claims, and that's not going to be good for the listing brokerage nor the seller.
Yeah, and along those same lines, Craig, this comes up sometimes with felonies and other things where the neighbors, of course, are going to be talking about this, especially if it was recent, and maybe they'll find out some other way. So they're wondering, should I be disclosing this? Should I not? That's a conversation that's important to have with your seller as a listing agent about, what do you want me to disclose up front, what not, or how do you want me to answer questions about this if it does? Because that can just disclosure, just because you don't have to disclose doesn't mean it's a bad idea sometimes. So it's just up to the seller how they want to handle that.
Yeah, absolutely. So that's the stigmatized property statute. Again, a place of homicide, other felony, murder. If the seller had HIV or other infectious disease that's no longer deemed to be infectious, or if the property's been properly remediated according to the local health department. So we got a question. Do you know when the legislature added decontaminated properties to the list? I don't know off the top of my head. I can see that this section of code was amended in 2004. So it may have been around that time period. Another question or comment, most every neighborhood has a 10-year-old kid on a bike that knows the history of the house. That may be true. In Bardell's case, would that be what, 1940, 1930? Something. No, I'm just kidding. So what else? Let me ask you this question, because we're kind of going in the idea of haunted houses, or not haunted, of stigmatized property. What about a haunted house? I have had classes where the listing agent and the seller are pretty adamant there is some supernatural occurrences on the property. Is that something that a seller would have to disclose to a buyer?
Well, Craig, I think by definition, a ghost would be immaterial, right?
Ooh, that's
Oh,
a,
is that a bad
ooh,
joke? Is that a really bad
that's,
joke? I mean, yeah, that's how I would view it, right? Is it material fact? Is it, I mean, seller can choose. I don't think it's outlined in the stigmatized property. So I don't know if there's any guidance there, but I would say generally it's not a material fact.
yeah, and the part of the issue is that in order for it to be material, there has to be a known, the seller has to have actual knowledge of the issue. And so proving that there are supernatural or paranormal activities going on the property, how do you prove that? How do you have actual knowledge of something to that degree? Now, I'll give a little caveat. There was a 1991 court case in New York, so that's not binding on Utah. Utah does not follow New York case law, but there was a 1991 decision where there was an infamous location, an infamous property, that the seller gave interviews to Reader's Digest, gave tours through this property, and held it out as a haunted property. Sold it to a buyer, didn't disclose the nature of the property or the history of the property. And soon after moving in, the buyer found out about information about the property and started to believe that, hey, this is a haunted property. The court, ultimately the buyer sued to have the contract rescinded. And the court said, look, this is something that the seller should have disclosed because of how the seller was holding it out as being haunted in the years previous. And the court determined as a matter of law that the property was haunted. And they said, look, if the buyer can't call on the court of equity, who are you going to call? And they wrote that in their opinion. And ghost, but so they went through the normal course of due diligence, maybe an electrician or a plumber, and they said, look, a medium doesn't fall under the normal course of due diligence. And so because the seller was holding it out as haunted, then it was haunted. Again, that's New York. That's maybe a little extreme, but it kind of goes to show that other states have dealt with sellers' disclosures. There's a question about wages. I don't think I can answer that. Assuming COVID is going to be falling under the HIV rule, I don't know if I would make that assumption. So COVID-19, I mean, that's a highly infectious airborne virus that we're dealing with right now. I think in the future, it could fall under the stigmatized property statute. Potentially, if the seller had COVID-19 but has since recovered, is that something that would require disclosure? I mean, I think it could fall under the stigmatized property statute, but looking at the language, let's maybe pull that up again. Oops, that's not it. Let's see. No, that's still not it. Where did my, oh, here we go. Okay, so let's pull this up. Let's share this screen. Let's look at the language again. So it says under B, the dwelling place of a person infected or suspected of being infected with the human immunodeficiency virus or any other infectious disease that the Utah Department of Health determines cannot be transferred by occupancy of a dwelling. As of yet, I don't believe the Utah Department of Health has made that determination with COVID-19. So for me, I would say it's safest to disclose if I'm the seller and buyers are going through the property. Um, that's where I would err on the side of caution on that point. Any thoughts on that, Lance?
No, I agree with that. I think the takeaway, of course, is disclosure is safest. Um, and talking to your seller and making sure you have permission about that is of utmost importance. But yeah.
Yeah, absolutely. Okay, I want to kind of shift gears. So we're talking about kind of hotline horror stories, and frankly, I really haven't had too many crazy examples. I'll give one at the end, but I want to address a little bit what was discussed last week on the hotline. Um, so let me pull up the post. Let's see if I can do this. The post that I gave. So I'm going to go to Facebook and show this. So the post that I created last week has garnered a lot of attention and dialogue and commentary about appraisal issues or language that I'm seeing being inserted into buyers' offers as maybe an inducement to get sellers to take their offer. And so here's what I want to highlight. So I'm seeing more and more buyers include language, and I give an example where they say, look, in the event of a low appraisal, buyer shall pay X number of dollars, in this case, $2,000 above the appraised value. And that's all they put in there. And the seller accepts the offer. The problems that I'm seeing with this type of language is, well, if let's say the appraisal comes in significantly lower than the purchase price, and then I've had questions on the hotline. Well, what is the purchase price then? Does it automatically reduce based on this language? Does it not? And I think those are fair points. In my opinion, I think it needs to say specifically that the purchase price is going to be reduced to match the appraised value plus whatever dollar amount the buyer is willing to pay above it. The only reason I share this and I come back to it today is the fact that I'm still seeing it. I have a hotline question right now where someone's waiting for me to call them back, where you as real estate agents have broad discretion to draft contractual language. Frankly, you have the broadest exception to the unauthorized practice of law that I'm aware of. It allows you to fill in state-approved forms on behalf of your clients. And one of the state-approved forms is the blank addendum. And so filling in the blank addendum allows you to use creative language, allows you to be flexible on behalf of your clients, but it also brings in ambiguity, and it also puts you in the position of a drafting attorney. You're held to the same standard, to be frank. And so I would just be very careful. The forms committee is going to kind of look at this to see if maybe we can help with that. But that is one of the reasons why the UAR has so many forms, to help agents meet their fiduciary duties and to avoid ambiguous language in your contractual drafting. Any things that you've seen, Lance, on that point, or anything you want to add to that?
Yeah, no, I agree with that. I think that's just a great reminder of just what a big responsibility it is to draft language. It's one of the hardest things I think that agents are asked to do. It's very difficult to do it well and do it carefully. And so going back to the contract is always a safe way, and using the language that is used in a contract, you're going to be much safer that way for sure. So there's no ambiguities.
Okay, so I'm going to give you some time to think about this, Lance, and I kind of gave you a heads up before we went on. I want you to think of a call or maybe a topic that kind of falls in line of this this hotline horror story. So kind of these examples, and I'll start with myself. Kind of the one horror story from the hotline that has left an indelible image on me. I mean, it was pretty. The events, and I'll lead to it. I'm kind of foreshadowing. Were pretty amazing, and horrific to a degree for sure. So let me give you my example, and then I'll turn the time to you. And then if you have any other questions out there, feel free to write them down. So here was the scenario. I had 3 separate calls within a 1-hour time period about the same transaction, the same scenario. So whenever I get multiple calls from multiple real estate agents, I know that there's going to be a serious issue. So here was the fact pattern. A young family made an appointment through their realtor to see a brand new property, at least the listed property. It was an older home, but it was just freshly listed. They go through the property with their real estate agent. They, like I mentioned, a young family, so they have a young, I believe it was a 6-year-old girl with them, and so they were going through the property. The 6-year-old was excited about the prospect of this being their new home, and so was really excited, kind of running around. And as they're going to go outside through the back door, the 6-year-old runs ahead, and it looks like the sliding glass door is open, but it was closed, and the 6-year-old girl ran through this glass door, and it was an older door, so it wasn't tempered glass; it was legitimately glass. And so, the first agent that calls me about this is telling me this narrative and says, "Look, this girl, I mean, obviously was life flighted, and had to go into emergency surgery, spend the night in the hospital, and the agent was saying, I don't know if they're going to survive." And I'm taken back by this. And so I have a dialogue with that agent. Another agent calls, same scenario, tells me that the little girl is going to be just fine, but is going to have to remain in the hospital for a while. So I mean, that was news to me, and I was grateful for that. Ultimately, all of these agents and brokers that are calling me are asking a number of questions. One, who's liable for this tragic accident? Who's responsible? What should the brokerages do that are involved with this? And so I gave a couple of answers as to kind of my opinions on that, and then how do I translate this to other areas? So first, I mean, is the listing agent or the listing brokerage liable for the little girl running through the sliding glass door? I'd say no. I think it's gonna be hard for the listing brokers to have liability. It's not a known defect. It's not a hidden defect. It's an accident. And so I'm not sure how the listing brokers would be liable. Same goes for the seller. Now, homeowners insurance, based on the policies, if there's an accident on the property, then there may be coverage there, at least for the initial accident. And then liability insurance covers maybe the more serious and certainly the liability if there was negligence based on the seller. So maybe in the initial portion, just the accident aspect, and then the liability, again, I'm not sure how the seller would be liable for that. Then the question becomes, well, is the buyer's agent or the buyer's brokerage liable for somehow allowing this child to run through the property, through the house? And again, I think it's going to be hard pressed to have brokerage liability. Certainly there needs to be a dialogue of proper etiquette to go through a property, but I'm not sure how the buyer's brokerage would be liable for something like that. And then lastly, would the buyers themselves be liable for the sliding glass door and the damage done to the property? In a general answer, if it was caused by the buyers themselves or the prospective buyers through their negligence, then yeah, there could be some liability there as far as property damage. So the only reason I kind of bring this up, I mean, obviously the details of it are pretty horrific, and thankfully the little girl is okay. But this liability issue, the idea that when is a seller and a listing agent potentially liable? If there's a known defect in the property that creates a hazardous condition, meth could be one, or maybe some sort of safety issue that is well known to the seller and the listing brokerage, those are going to need to be affirmatively disclosed if they create that health hazard. In Utah, after this scenario, I did look into my own insurance and and asked what were the most common claims for homeowners insurance, dog bites and slips and falls on the property. So in Utah, ice, snow, we still sell properties in the winter. We had snow just this week. Those are things that could cause liability. These are invited guests. They have a right to be on the property because they've made an appointment. So this may be over an abundance of caution, but it may be prudent for listing agents to have a discussion with their sellers about the liability aspect of their homeowners insurance and ensure that there's proper coverage there, because you are going to have invited guests viewing your property. And if something happens, then they want to make sure that they're protected. And that's something that agents can show a value proposition by highlighting something that probably won't happen, but could give some protection in the event something does happen to their clients. So that's the one, sorry for the lengthy discussion or dialogue on that, but that was the one, one scenario that just stood out in my mind. I mean, it was horrific, kind of the details about the little girl, but it kind of went on to maybe a broader theme on that. Any scenarios or themes, Lance, that you would think of that you've encountered on the hotline?
Yeah, I had a story come up the other day that scared me a little bit. Not quite as scary as yours in some ways, for sure. It's more about money. But I had a buyer's agent give some advice that put him in jeopardy, I think. And so let me tell you what happened. They were under contract. They were settling. They went to settlement. And the buyer's agent or the buyer said, I can't deliver the money till tomorrow morning, right, for settlement. And their agent said, great, just wire it over in the morning and I'm sure it'll be fine, right? And I'm sure a lot of times that is fine. But if we go to the contract, that's not exactly what the contract says, right? Settlement, and knowing what settlement is really important. It says delivering and signing documents and delivering any money owed except for proceeds from a new loan, right? That's comes in with closing. You have 4 days to do that. So when that agent gave that advice, he's on thin ice, right? When he's not being specific in his advice on what the risks are of doing that or what not, if the buyer decides to do that. And so what happened is the next morning, once the money was not delivered, the seller canceled, said money wasn't there. They were actually waiting for a breach. They were looking for a breach because the seller was upset. It was an expensive property. It was over $1 million. And they had other offers after they went under contract for much higher. And I think it was about $100,000 higher. And so they were looking for a way out of that contract, unbeknownst to that buyer. But once that came up that they had breached or a potential breach, they jumped on it and said, nope, we're going to cancel for this breach. They saw it as a breach and they canceled. And that to me is very scary when you give advice that that isn't specific and you're not going back to the language of the contract saying, well, let's look at our options. What can we do? Can we extend? Can we do something else that is a little bit safer? And so how does that play out? Now, I don't usually get the end of the story, right, on the hotline. I'm not sure how it played out, but I can see it playing out in several ways, whether a lawsuit or that agent coming up with the money and they still close, or they renegotiate and say, well, we'll pay a little bit higher, and that higher price might come from the agent if that was the agent's fault, as part of a negotiation or something. But that to me is scary when I think of just reasonable care in a contract and really being careful and slowing down when giving advice. But yeah, that's a shorter one, but something that scares me a little bit.
Oh, for sure. Reasonable care and diligence. I mean, that out of all the fiduciary duties, I mean, those are, I don't want to say the scariest, but they have the broadest interpretation for real estate agents. And so that's where you certainly have to be careful. Looking to see if there's any questions. There was a question about why Utah housing prices are increasing so much. I think there are certainly some factors, and I'll maybe give some broad, maybe Lance, if you want to highlight anything. Compared to previous years, there's limited inventory. So when you kind of look at the economics of supply and demand, there's much higher demand than there is supply. And when there's lower supply, then that drives up the purchase price. So just from a sheer economic standpoint, that's really kind of what I've seen, that the demand is high, but then the supply that's available is much lower than in years past at the same time period. Those are really the kind of the considerations there. And we certainly have the demand based on people already living in Utah, and then people certainly wanting to move to Utah or moving to Utah are kind of the things that I've seen based on that. Any other thoughts, Lance, or considerations?
Yeah, I just think Utah's awesome. I think that's why people are here.
It's a great place to live.
A lot that people are coming out of state a lot, especially now. And so it's a great place to live. So that's why
Yeah.
I think.
I think so. It's a fantastic place to live. So it is a hotline period. It looks like I have 6 or 7 questions just on the hotline of people wanting to talk to me and talk to Lance. So we'll certainly want to get to those. If you do have any questions, feel free to call the hotline. Just leave a message and we'll get back to you as soon as possible. It is open Monday, Wednesday, and Friday from 8:30 to 4, but you can leave a message 24/7, and we try to respond as quickly as possible. And if there's a subject or a topic that you would like us to cover on either these or a legal tip, feel free to comment below, and we'll certainly try to address those in future legal hotline lives that we have on Facebook. So thanks for joining us, everyone that logged on and watched with us. Thank you, Lance, for your experience and for your commentary and expertise on this. And thanks, Deanna, for putting this together. Until next time, everyone be safe out there. Bye.
See ya.